My father's about your age, and he always said, "Kid at heart," and that's very true.
Hit it hard?
A kid at heart.
Oh, kid at heart. Oh, you said hit it hard.
No.
Now, wait a minute.
I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
Flirting with the judge in front of my dad.
What's going on? How's everyone doing? This is Colin. Happy Wednesday. Yeah, I've got a randomness of a collection of court clips for you this evening. I was going to make it a video. I'm like, you know what? Instead of waiting all that time for it to upload, I'm just going to go live. How's everyone doing? Mimi, Melanie, Jonathan, Nancy, everybody, Tim, thank you so much for coming. Sure, other people are going to roll in here shortly. Yeah, got some good ones. Hopefully my mic's working. My internet doesn't crap out. It already seems like there's a little bit of an issue. But before I hit the play button, you already know what to do. Like and subscribe and do your jump kick backflips. And if you would like to, you can donate to the Stop Colin from Quitting YouTube Fund. A little bit of a joke, but yeah, kind of. All right, let's go.
1:30 calendar here with us in person.
Okay. Last name again?
Denny, Robert Denny, number 5.
Okay, that's number 3A730239.
I brought these. I didn't know.
Mr. Denny's here today for arraignment for 1 count of driving under the influence. Good afternoon, sir.
One account, yes.
Okay. Ms. Lash.
Thank you. We are not asking that public defense be appointed in this matter as he has already retained counsel. That counsel is not available to be here today, but will be moving forward, is my understanding. We're asking the court to enter a plea of not guilty. We are stipulating probable cause for today's arraignment.
All right, then, Mr. Denny, I'll enter your plea of not guilty. And is your mailing address on Bainbridge Loop Northeast in Lacey?
Yes.
Okay. And then the state's position on release?
Yes, Your Honor, the state has no objection to PR with standard DUI conditions, no criminal law violations, no drugs or alcohol, no bars or taverns, no driving without valid license and insurance, and no refusal of BAC. No objection to the defense.
All right, so private counsel pre-trial? December 13th. All right, then, Mr. Denny, you're released on your own recognizance, okay, on conditions. Don't violate the law, don't drive without a license and insurance, no alcohol, no bars or taverns. And your next court date will be on December 13th at 2:00 in the afternoon. All right, we'll give you that in writing.
They're going to print out a
I was going to say that. I was going to ask if they printed, if they gave you a reminder.
Yeah, we're gonna print it out right now.
My memory has gone a little bit south.
Probably will get through the review.
Something to do with age, I think.
You're not that old, Mr. Denny.
You're not?
Trying to be positive.
You want to guess? No.
I am not gonna do that.
87.
Congratulations.
My father's about your age, and he always said, "Kid at heart," and that's very true.
Hit it hard?
A kid at heart.
Oh, kid at heart. Oh, you said hit it hard.
No.
Now, wait a minute. That tells the date.
Exactly, yep, it'll be on the second to last.
All right, thank you.
Thank you very much. And unfortunately, I'm going to have to meet with some more folks. I'll be as fast as I can.
Okay, just take a recess then.
Oh, I apologize. I was going to say, I do have several dismissals or cases that will be asked to dismiss.
Okay,
All right.
why don't we do those and then we'll take a recess.
I thought I paused it. I guess I didn't.
Okay, start at the top then and just go through
Let's
calendar order.
end.
First one is McKenna Davis. Cause number is 6940. The
Okay.
state is asking to dismiss without prejudice.
All right,
All
the
right.
Davis matter is dismissed.
The next one is Mary Paris. Cause number ending in 08, oh, sorry.
All right, this isn't going for very long.
8591.
Okay,
Maybe like another
State is
30
asking to dismiss
seconds.
without prejudice.
all right, the Paris matter is dismissed, and I think I see Miss Paris logged in. Miss Paris, if you can hear me, there we go.
Yes.
Okay, so
hello.
Ms. Paris, the prosecutor has dismissed the driving while suspended charge against you, so you can put that behind you and you're free to
I
go.
knew that was going to happen. I knew
Okay.
that was going to happen. All right. That's what happened. I forgot to clip out the end of that. I wasn't going to add the whole case. I just thought that old guy was charming. 87 years old, charged with a DUI. I mean, I think it was Patton Oswald that once said, once you get to certain ages, you shouldn't be allowed to be charged with certain crimes. I mean, he's a comedian, so he made a little funny bit about it. But 87, I mean, I know DUIs are serious. I'm not taking anything away from that crime. He's 87, and he's still driving, and he's still getting drunk. Not gonna lie, I hope I'm doing those two things when I'm 87, but not at the same time. Let's be fair. I'm not saying what he did was right, but he was charming, and yeah, the hit it hard part, it was funny. It was funny. It's 87, and he's still going at it. Still going at it. All right. Like I said, this is a giant collection of randomness, so I don't know what's coming next. I know what's at the end. I don't know if the next clip is off the thumbnail or it's the next clip. I don't know. So let's find out together. Let's go.
Land, Eveland.
Reno!
Yes, hi. Good morning.
Good morning. What are we doing with Mr. Eveland?
Your Honor, candidly, I was a bit confused as to what all we have him here on. There was this older case involving trespassing at the pepper mill, and then, excuse me, I'm looking at someone else's. There was an older case and there was failure to appear. Is there a separate matter, Mr. Altum, or is it just this failure to appear on the older case?
So I believe that there was some indication in the risk assessment pretrial documentation that he has a suspended sentence in 23 CR 05520.
Mm-hmm.
And I'm looking that up right now. That's a let's see, also a trespass case. And he does have a 30-day suspended sentence from May 2023.
And that's separate from the one in which he's on the failure to appear here.
Correct.
Understood. Okay.
All right, what do we want to do, guys?
Your Honor, with regard to the older case, or at least with regard to the failure to appear on this case, it sounds like Mr. Eveland was in custody in Carson City at the time of the missed appearance.
Mm-hmm.
And so his interest is in getting this out and resolved. I guess our request would be, he would ask that the warrant be quashed for the failure to appear because of legal impossibility. He was in custody. That the trespass be set out for a bench trial, and that the suspended sentence be left undisturbed, or that he be readmitted to that suspended sentence.
Mr. City Attorney, what's your thoughts?
It sounds like the defendant is not admitting any probation violation, doesn't want to plead to the new trespass. In that case, he'll need some bond since he has these issues of not showing up. I don't have any reason not to believe Mr. Edgerton that the defendant was in custody in Carson City, but he has no employment, no fixed residence. He already had a suspended sentence in a previous case. He was reportedly unable or unwilling to answer the risk assessment questions.
I never had a risk.
Given all that, I think a $500 bond is appropriate.
All right, Mr. Eveland, we've got it'll be your suspended sentence on that trespassing charge under 23 CR 05520. You're reinstated on probation. You're not going to be revoked. On the failure to appear on this charge 07820, I'm going to quash that warrant based upon the representations of Mr. Edgerton.
Thank you.
We're entering a not guilty plea on the trespass, and I'm going to make it a $500 bondable.
Could I please, could I just plead guilty on the trespassing one? The one that you're talking about for 500?
Mr. Evelyn, the tricky thing there is that if you were responsible for committing some other act while you're on a suspended sentence, then the court would pretty much be boxed into giving you 30 days on that older case.
I cannot afford $500, sir. I can't afford $500. And I mean, I just got out yesterday. I was only here for 3 hours coming back from Carson City, and I was headed to the courts to go ahead and go ahead and make sure that everything was good and on the up and up. I was headed there. That's where I was headed yesterday. I just got back 3 hours before I got arrested. So I only was in Reno for 3 hours.
Mr. Evelyn, I think the options that the judge has set bail at a very low amount, 500 bondable. So if someone could put up about $75 for you on the outside. Okay. The other option would be we could change your plea. You could admit the failure to appear, admit this new trespassing, ask for the 30 days to be imposed, and then wipe up both cases with 30 days in jail. We're kind of between a rock and a hard place, Mr. Evelyn.
Well, how long do I got to sit here in this jail for?
Mr. Ebon, this is the deal. You've been breaking the law. There's no, we're not going to give you an early Christmas present on this one. This is what we're going to do. I'm going to reinstate you on that possible revocation on 23 CR 05520. The failure to dismiss is quashed based upon representations from client. And on the trespass charge, I'm going to take it down to a $200 bondable. You can't make that, then you're going to stick around. You're the one that put yourself in this position. We can only do so much. Martha, go ahead and give us the trial date.
Give me a minute, Judge.
If I plead guilty, then I'm going to get a violation.
Right, Mr. Evelyn. The other
30 days. Go ahead.
Right, that would be other option.
So if I plead guilty, I would get a violation? Huh?
Go ahead and give them a date, Martha. Yeah, that's the deal. You plead guilty, you're going to jail. You're going to go 30 days in jail. You're going to get revoked. You're going to get time served on the most recent one. So you're looking at 30 days in jail. That's the reality behind it. Otherwise, we're going to plead a not guilty, and we're going to set this matter for trial and give you a low bond. Go ahead.
December 11th at 1 o'clock in the afternoon.
All right. Thank you, sir.
What is it?
December 11th.
December 11th. Dude, I don't agree with none of that.
All right. Let's go to Luis de la Cruz.
I don't agree to none of that. Yeah. Stop going to the pepper mill, man. Stop going to the pepper mill. Why? I don't understand why people keep going to the pepper mill. I mean, I've looked it up. I think I've said this before. The place looks amazing. I watch Reno just about every day because I love Reno. I call it my Saturday morning cartoons, which some of you know. So I watch a lot of Reno. Half the cases stay away from the pepper mill. I think it's the only casino in Reno. I know that's not the correct thing to say. But from all these people, yeah, it kind of is. All right, Mike, what's up, Denali? How you doing, buddy? All right. Again, I've got 3 more cases. The last one's a long one. I don't know if this next one is the woman with a ton of tickets or if it's from the thumbnail. I think it's on the thumbnail. All right, let's go.
All right.
Nope, not the thumbnail.
Now calling the matters of the people versus Khadijah Williams. This is ticket number SP 1225990. Count 1, improper lane usage. Count 2, no registration or unsigned registration. Count 3, failed to secure a child over 4 years old and under 16 years old in a safety belt. Ticket SP 1226580. Count 1, failed to secure child.
My apologies. I was in the breakout room. I thought you guys were still in sidebar. I didn't get the first part of it.
Okay.
Can you start over again, please? Thank you.
I can. Oh, it's the offering. All right. Now calling the matter of the people versus Khadijah Nicole Williams. This is ticket SP 1225990. Count 1, improper lane usage. Count 2, no receipt of or unsigned registration. Count 3, failed to secure child over 4 years old but under 16 years old in a safety belt. Ticket SP 1226580. Failed to secure child under 4 in a car seat. Ticket number SP 1225998. Count 1, failed to properly secure passenger child. Count 2, failed to secure child under 4 years old in a car seat. Count 3, failed to secure child under 4 years old in a car seat. Ticket number SP 1225975. Count 1, driver's license never acquired. Count 2, open alcohol in a motor vehicle driver. Count 3, no insurance misdemeanor. This is the date and time set for the second bench trial in these matters after numerous pre-trials. Appearances for the record, starting with counsel, please.
Did anyone pick up on how many tickets those were? I know she had to repeat the first couple because the court reporter was AFK, but yeah, that was a lot of tickets. I was trying to count and then I started reading chat and lost count. Did anyone get the amount? I don't know. There were a lot.
You still, Attorney Mason, can you state your name for the record?
For the record, Your Honor, Dia Chiku Mason, City Prosecutor, 43471.
All right, and Attorney Miller.
Good morning, Your Honor. Alexandra Miller, P86290, on behalf of Ms. Khadijah Williams, who is present via Zoom. Ms. Williams, can you please unmute and state your name for the record?
Good morning, Judge. Khadijah Williams.
All right, this is the date and time set for a bench trial. Are we ready to proceed at this point in time?
Your Honor, at this moment, as I indicated in sidebar, we are unable to proceed at this moment. There's been a clear breakdown of attorney-client communication, and for that reason, I am requesting or putting forth a motion to withdraw as counsel for Ms. Williams to be able to obtain her own counsel.
And just so the record is made clear, we did have a sidebar, myself, Judge Taylor, as well as Assistant Prosecuting Attorney or City Attorney. I'm sorry, I'm so used to Assistant Prosecuting Attorney. City Attorney, Ms. Mason, in a breakout room off of online to discuss this matter. Attorney Miller relayed to me that there was a breakdown in communications between her and her client at this point in time. So with no objection from Prosecutor Mason, well, first let me ask. Ms. Williams, is that true? There's been a breakdown in communication?
I don't want to take the cop that they're trying to give me because I was told that today would be the trial, and I'm steady being told like, to try. Okay, but I'm being told that I would have to take the
right now,
plea.
Ms. Williams? We can definitely have a trial right now. I don't mind.
Okay, because would you be able to view the videos and everything, Judge? Because
I'll definitely view the video. That'll be a part of evidence that they will put in. And then I'll render a decision based on the law and how the law goes and how the law operates. So I'll render a decision based on what I see and the practices and what the law says that I can do based on that information.
Okay.
You don't have to take, excuse me, whoever's talking in the background, please stop. I'm on the record and I can hear you, and you are not a part of this particular hearing. If you would like to be a witness, that's fine. You'll have to stop the car. You'll have to get out the video. You'll have to get out the vehicle. You'll have to be in separate rooms and will be sequestered during the trial if they would like to say it. So that's how that works. If you would like to have a trial, we can have a trial. I don't mind.
Yes, that is fine.
Okay. Attorney Miller, are you still willing to represent her today or no?
Ooh, sorry, I was muted. Your Honor, I'm willing to represent Ms. Williams. I was just trying to explain to her what would happen if she did not take the offer by the prosecutor. And like I had told you in sidebar, I have to present any offer given to my client and explain that offer. And I had explained to her that if she did not take that offer, all of the tickets that were then read into the record, she would be facing. And then and so I have no problem proceeding, but I just want to ensure that Ms. Williams would be okay with my representation since it seemed like she was unhappy.
Okay, I agree. I understand. So that's why, Ms. Williams, are you okay with this, Attorney Miller, moving forward at this point?
Yes.
Okay. All right. Well, if do y'all need any more prep time, let me see if they have any more folks who are ready to go. If not, I'll get started with this trial. So Attorney Mason, did you need a moment to talk to the officer? I did bring the officer in here. You need a moment to talk to the officer before we
Yeah, I'll put her
proceed?
back in breakout room one,
Okay.
Your Honor.
Okay, cool.
All right, we should be fast
Officer
forwarding a little bit now.
Siskowski, we're go back to breakout room.
Yep. All right. So to answer a few questions, first, Fish, I think Fish on, you were the person that said about the soft sit. I don't have a soft sit in this video. I know maybe the thumbnail was a little misleading, but that dude is a little out there. That clip's coming up after this one. This woman is not driving. She's in the passenger seat. Her husband's driving. And you're about to see a little bit more of him here in a minute. Also, this woman's attorney, she's like brand new. She, during this entire docket, she was PMing the judge through Zoom, and the judge actually had to tell her, like, you need a mentor to know how to contact me, because that's not how you do it. The judge was really polite about it, but you can tell that this is a new attorney, and this is probably the first time she's kind of had to say, I need to leave this client. This client's out there. But yeah, all right. Let's watch the rest of this.
For counsel to get back up there, Attorney Miller, we can handle this matter now. Ms. Williams?
Yes.
Recalling the matter of the people versus.
Oh, Miss Marlene, I'm sorry, Miss Taylor, can you give me a minute? I have to pull over. I know you told me I can't be in motion when my husband's
It's okay, we're not having a trial anyways today, so.
Okay, tell her you want a more experienced lawyer.
Oh, not only am I going to give her a new attorney, sir, it's gonna be down here in person, and we're gonna have to push it off to next year. How about that? How about that's what we're gonna have to take place, okay? Since he got so many things, and he got so many things he wanna say, and he wanna be a part of the hearing, although repeatedly I have asked him not to. And I know it's not your fault, Ms. Williams, but the reason why it's gonna be delayed is because I do have to put new counsel into place, and now I have to wait for counsel to be assigned, because you probably can't afford counsel. Am I correct, Ms. Williams?
Correct.
Okay, even though, okay, I'll leave that out. So counsel, so now I got to get different counsel assigned, and that counsel has to come on board. And then I have to set a new trial date. And then that trial date is going to be in person, okay? So I'm gonna recall these matters, the people versus Khadijah Nicole Williams in these particular matters. Can I have appearances once more? Nope. Miller for the record.
Yes, good morning again, Your Honor. Alexandra Miller, P86290.
All right, and then attorney prosecutor.
Yes, for the record, Your Honor, Dia Chiku Mason, City of Detroit prosecutor, 43471.
All right, and then Ms. Williams, can you state your name for the record once more again, please?
Yes, Khadijah Williams, Miss Taylor, Miss Marlene, can I? So since I have to come to Detroit, is it possible that I can still do a jury trial then?
Yes. Yeah, you can do a jury. You can always do a jury trial. I just have to have counsel assigned to you. Please tell your husband to close his mouth. Please, please. He is making me raise my voice in here. He got so much to say. He should have been driving you around that day. Okay, Miss Williams, this is me and you talking. Okay, this is Judge Taylor and you talking. Don't let someone who is in there and doesn't have these 11 tickets dictate to you what you should do. Okay, I'm not telling you not to have a trial. You have the absolute right to have a trial. You have the absolute right to have a bench. You have the absolute right to have a jury trial. But Miss Williams, I want you to think with a clear conscience and just don't let somebody, if somebody's willing to come on the record and be disrespectful to me as a judge, sitting up here, holding a hearing and just shouting out, you wouldn't dare do that if you were in another county. You want to know why? Because they would tell you to come on down here right now, and they would go ahead and place you over in the jail for a moment, because I've asked not once, not twice, but 3 times for him to stop talking. That's called being held in contempt. All I'm asking is that he does not participate in this court hearing, because I can only have one person on the record at the time, and that's you, Miss Williams. Okay? So I'm going to get this going. I'm going to get what we need to get going. All right, so at this time, Attorney Miller, I am going to excuse you. I'm going to allow you to withdraw from this case. I do believe there's been a breakdown in communication. Ms. Williams, I'm gonna have to get new counsel assigned to you. Do you have, or do you want to try and get your own counsel? Let me ask you that, Ms. Williams. You can unmute yourself.
I wouldn't be able to.
Okay, all right. So, Ms. Williams, the next counsel I give you though, you need to work with them and talk to them. Okay, this is not going to happen again. This is a case that happened back in 2021, and we are in 2023 going into 2024. This is lightweight ridiculous. Now, I understand all of it wasn't your fault, okay? All of it was some delays with some pre-trials, and then we had a bench trial, and you need a counsel assigned. Some of that I understand, but this is going on for quite a bit of time. And at this point in time, we either gonna move forward or we gonna take a plea. You said you didn't want to plead, that's fine. So we're gonna move forward. We definitely can have a jury trial in these matters, okay? To get counsel assigned right now. All right, Attorney Mason, did you have anything else you need to say at this point?
No, Your Honor.
All right, and I do have the officer on board. Officer did appear for the bench trial today. It's going to be a jury trial when we have it, so it won't be until next year, officer. Just FYI for you, okay?
No problem, ma'am.
Okay.
All right, state your name for the record, officer.
Officer Kylie Sukowski, badge
Okay,
442.
all right. Ooh, I'm so sorry. Did you get all that, Sandy? You might need to say the end of it with your badge number. I was talking. I apologize.
You're okay, ma'am.
432.
4422.
Thank you.
All right.
And Officer
You're
Sukowski,
welcome,
when you get a
Ms. Sandy.
chance, go back to the breakout room so I can get your phone number again.
No problem.
All right. And Ms. Williams, I'm going to have you come back on, let's see. I got to pull up my calendar so I can see when I can have you come back. I want to make sure we put counsel into place so we can pick our trial date for next year, okay?
Okay.
Okay. Let me see. Come back on Thursday, November 30th, okay? Via Zoom, the same way you zoomed in. This will just be to make sure we have counsel in place. I'm gonna have them talk to you for a while that day too online, so be ready to talk to them, okay? And then be ready to so we can pick our trial date, so I can set us up for a jury trial for next year, okay?
Okay, November 30th of this month.
Yep, November 30th via Zoom, okay, that day, so that we can have new counsel assigned, and then we can pick dates from there, right? I can't just pick dates and they don't work with counsel, okay?
Yes.
All right. All right, I'll see you then. Bond set at $0 personal, all right? Have a great rest of your day.
Thank you. Have a great one as well.
All right, that was fun. That was fun. Just responding to Lucy real quick. You said that the messaging the judge was inappropriate. It is. She didn't know. She was trying to. What was she trying to do? She was trying to let the judge know that there was a breakdown in a relationship with her client and wanted to withdraw. She didn't start that conversation. So she did do it. And the judge, they had the breakout room. And then after the breakout room, the judge said to her, "Do you have a mentor?" And actually brought another one of the public defenders on and like, "Hey, do you have his number? Call him. He will help you out on how to communicate properly." It was, I will agree with you, it was inappropriate for her to send a judge a PM over Zoom, but at the same time, the judge should help her. So it's, she did the right thing on that part. Just respond to that. Yeah. Okay. This next one, this is the thumbnail clip. This dude's wild. I'm not going to say anything else. This dude's wild.
All right, what is your name in the jail there, sir?
It's Mr. Laird.
Are you Mr. Laird? Okay.
Why are you listening to my court date?
I'm not, but he's talking.
I have the
to you.
right to remain silent.
Okay, well, you can speak to the judge.
Okay,
I have the right
I
to remain
just
silent. I
wanted
have
to
the
make
representation right there.
Mr.
talk to
Laird,
my
I
lawyers,
just wanted to, Mr. Laird, I just want to make sure you can hear
Intimidating
the
a witness, Your
proceedings.
Honor. He's not even, yeah, I'm aware of them. I don't have to talk if I don't want to. And you just had one of your officers approach and he's listening from outside. So my lawyer's right here. He can speak for me. So I'm allowed to remain silent. So this is farce off rip.
Okay, thank you.
He
So
approached me.
this
I'm sorry,
is-
Matthias. He approached me.
Okay, so this is file 8789 of 2023, People versus Nicholas Todd Laird. And Mr. Johnson is here on behalf of Mr. Laird here in the courtroom. And Mr. Atwood is here on behalf of the people. This is the date set for a competency hearing, and it's my understanding Mr. Laird has been found incompetent. Is that correct?
A few months ago, Your Honor, and I would agree with, quite frankly, Mr. Laird, that this is somewhat of a farce. He's not getting better sitting in the jail. He's not being treated. There was a finding of this, and
So is this a situation where the forensic center said he would benefit from treatment and they just don't have a bed available for him?
that would be my guess, Your Honor.
Correct, Your Honor.
So what's your position on that, Mr. Johnson?
I don't know that I can have a position. My position is if we could do an order to order them to come and get him, that would certainly be I know in circuit court, we had some success where we can't get the criminal responsibility by the time of the trial date, and having our circuit court judge issue an order to show cause.
Well, they're scarier than I am.
I don't know what else we can.
May I say something as well? I've had two
Yes.
competency. I've had two
Hey,
competency
hang on,
hearings while
hang on.
one with
Mr.
Dr.
Johnson,
Audu
is it
and one
okay
with
if we hear
Rampart.
from Mr. Laird? I don't want him to say anything that might incriminate himself.
I don't think it would be incriminating, Your Honor, but I think Nicholas talks about the fact that he's had multiple of these interviews and nothing's happened. And that's, I guess, his frustration as well.
Okay, I can understand that. So, Mr. Atwood, what's your position?
Your Honor, I think the only option is to wait for a bed or to show cause at the center. I think those are our two paths going forward. It has been several months. I think it's kind of ridiculous if we're still here waiting on a bed, but that's just the reality, I think, around the state right now.
Okay, so I think we will schedule this for a show cause hearing. Let's see, I guess who would I be show causing? The director of the forensic center?
That's what circuit court has done in the past, Your Honor, and I think the more we can,
What's their response been? Because
they showed up, and I think it worked in that instance, at least the one I'm familiar with Judge Power. So if they're inconvenienced in that way, maybe we grease the skids a little bit.
Okay, so that's what we'll do, and we'll schedule it relatively soon. We want to give the director sufficient time to get this on their calendar, keeping in mind that Mr. Laird is sitting in jail. So, Ms. Martin.
You guys know you're not allowed to listen, right? You're going to cause a mistrial, just so you know.
Do you want to do it in like a week, November 15th?
Yeah, that sounds like enough time for them to get somebody.
Three, and we'll do it at, just do it at 10.
Say on the 15th.
Yeah, yep.
All right, so is that gonna work, Mr. Johnson?
Yes, Your Honor. It's on Zoom because he's there. It's on the intro, but that's fine.
Okay, we're gonna see you next week, Mr. Laird, and we're gonna have the director of the State Forensic Center here to explain why they haven't gotten you into a treatment facility. We're all set. If you could let that officer know that we're all set for this morning, I would appreciate it. Bruce, you might have to call and let them know. Oh, he's leaving. Okay.
Fish. I honestly don't know what his charges were. I don't know. I don't know. That was a court that I don't generally watch, and I just remember running across that real quick. I'm like, this guy might be kind of hilarious. Yeah, yeah. All right, last case, and got a little special guest coming in for this last case. You'll see. Let's go. But if you haven't done it already, please like and subscribe. Do your jump kick backflips. If you would like to donate to whatever, I'm going to rename the fund. It's down in the description. Also, Biggin just went live, and I'm redirecting us all to Biggin after this stream. So, got one case left, and then we can go all hang out with Biggin. All right, let's go.
Going nuts, and his wife starts going nuts. It's just a family of Karens.
Guarding.
I love Middleton's
Dangerous dog.
His kind of intros that he does. He actually addressed me the other day. He addressed a couple of my comments. I'm still waiting for him to answer this question, though, Judge, if you're watching, because you said you would. I asked him, has he ever watched my videos? He lied and said he didn't. But he wasn't under oath, so it's okay. You are going to be in this video whether you fucking like it or not. Delicious little menu. I was driving along yesterday and I was recording back here on the computer, was recording the one that I put out yesterday. I can't remember. The one where the judge puts that arsehole's dad in jail for cursing at the back of court. So I'm driving along and I was running out to the shop to get something for the dinner and flying back home to do the video, right? And I got a call off one of the boys. Can you come up and help me with something? I was like, oh, shit. I couldn't say no. So I jumped in, kept going, went to his gaff. And the whole way up, I was thinking, Colin's going to nail this one straight away. And I thought, okay, cool. Because Colin fucking, he just has this radar for these crazies. But anyway, that's neither here nor there. So I was coming back and I was literally thinking, what would Colin say about this particular part or this particular part or this particular part? And then I watched it. I was like, that's exactly what I thought he was going to say. So we're in unison in that. Oh, yeah. Also, I did get your message. For some reason, I can't message back, but I can't message back anybody on that app. So I need to delete it and re-download it, methinks. Anyway, I've never had corned beef and cabbage, believe it or not. All right, let me skip on to where it gets juicy. Colin, I don't know if you saw my most recent video, which was a similar case to the one we both covered yesterday in Judge Stevens' court. If you did happen to see it, if you're doing a live stream or doing anything like that later, I'd love to hear your words on it because it was an interesting one. It came out today. Sorry, it was just weird.
Anyway, tell Colin I'm ready.
So, all right, challenge accepted. Irish Demon wanted me to react to this, so let's react to this. Just gonna warn you, I wasn't gonna do this clip. I didn't want to. Time Served did it yesterday. Irish Demon did it this morning. I was gonna delete it. I wasn't gonna cover it, and then I got that little shout out from Demon. So let's go. And yeah, for everyone who was just saying they can't watch that clip again, I don't remember who said it. I wasn't gonna play that clip again. I covered that yesterday. I'm not gonna do this again. This is trigger warning. I'm gonna trigger warning you all. It's not a fun case. But Judge Stevens, he comes through on this.
You will be taken into custody. And Mr. Walker, that's you. Come on and get a resetting. You're free to go. You got it? Okay. You're free to go. He's in custody. Yeah. When you flunked the drug test,
I love that, by the way.
You were immediately taken into custody.
You're free to go. Not you. You're in custody.
I have Mario Hernandez.
Ready, Jeff? All right.
Come on up.
All right. Here we go. No, winner which this is not a dog person.
22-40195 is called Mario Hernandez. That's you?
Yes, sir.
Present. With Mr. Kelly, your attorney in the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
We do, Your Honor.
In summary, this indictment alleges that on or about March 10th, 2021 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, prosecuted for the lesser included offense of Okay. What is the offense?
Indecent assault. Class A.
You saw that right there. Judge Stevens just read what the charge was, and his whole demeanor just changed. Yeah, this is a serious case. This is a serious case, and I know Debbie doesn't like Judge Stevens. She was telling me about it the other night when she was on stream. I have a love-hate relationship with Judge Stevens. I think he got it right here, and I said that before.
What's the section number, please? I got 22, I guess.
Hey, Glitter Fart's in the chat without being in the chat. Sal, you can't lie. You took that from Glitter Fart.
Mm-hmm.
Maybe he took it from you. I don't know.
Indecent assault 22.012. A person commits an offense without the other person's consent with intent to arouse or gratify the sexual desire of any person. Person touches the breast of another person. This is a Class A misdemeanor.
Correct, Judge.
So let's go back. So the punishment range is not second-degree felony. It's Class A misdemeanor, right?
Judge, I'm sorry. I fill those out based on the allegation, the indictment, what we're ultimately leading to.
I can tell by the chat most of you have already seen this, which is fine. I did link Irish Demon's video on this description, so if you guys want to check him out, please go. He has a great channel, and he's really nice to me. He gives me a lot of shout outs, so if you're not subscribed to him, at least go give him a couple of views. But yeah, this guy, I just love how Judge Stevens, his demeanor changes. Talking about people doing drugs on probation or parole, and you can just see his face. He's also not eating gummy bears right now. That's how you know it's serious. That is what he eats, by the way. He did say it. He said it in one of his videos he has a bowl of gummy bears on his desk, and that's what he's eating throughout. When you see him eating, he's eating gummy bears. I see that, Jonathan. I see that. I see your message. Irish Demon does the correct thing to do, though. He asked me first, and then he gives me a shout out. That's the way to do it. So I will never be upset about that.
Sure. I've agreed that you would be pleading guilty to lesser included Class A misdemeanor indecent assault.
I actually have a video on that. Of him. It wasn't 15, it was $18 an hour. He's like, Judge Stevens says you're making $18 an hour. You're making $40,000 a year. You can afford an attorney to help you fix your mistakes you made. I did the math on that. $18 an hour was it was right around 35. It might have been 36, it might have been 34. It was right there around there. It's expensive to hire an attorney. I did not like that comment. This is why I have a love-hate relationship with Judge Stevens. $18 an hour is not $40,000 a year. Even on $40,000 a year, if you're, I mean, it's not a little bit of money, but when you're supporting yourself, okay, I'm going on a rant. Let's just watch this. Sorry. I'll put up that video tomorrow and I'll say how I feel about that. Yeah, I agree. I wasn't happy with that. I don't remember what the guy's charge was.
Which is found under section 22.012 of the Texas Penal Code, which carries with it up to 1 year in the county jail and or up to a $4,000 fine. Do you understand the punishment range?
Yes, sir.
The agreement is that you would be placed on deferred or unadjudicated probation for 2 years. Is that your understanding of the agreement?
Yes, sir.
Also fined $500.
Yes, sir.
If I follow that, you have no right of appeal of your case. Do you understand?
Yes, sir.
Mike just jumps in from time to time and just puts random comments and walks away. Love you, Mike.
How do you plead to this Class A misdemeanor, lesser included offense under this indictment? Indecent assault, guilty or not guilty?
Guilty.
All right, I'm going to stop
guilty
laughing.
voluntarily and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes,
Is
sir.
that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes.
Yeah, this is the deal. This is the deal that he pled to. I don't know if it was a great attorney or if his defense attorney is amazing. I don't know if the prosecutor just kind of dropped the ball in this, but I don't like this. I don't even know how to say this. You have a crime against a child. No. There's no deal. Any parent.
Printing's getting smaller.
Any parent would say that. There is no deal. Judge Stevens he put his glasses on. I'm telling you. Mimi, you're right. The judge does have the final say. Ellen, I agree. I would not want to stand in front of Judge Stevens. I wouldn't want to be an attorney in front of Judge Stevens without multiple years of experience. He's intimidating. Yeah, Fish, you're right. They can. That might be, but that's. I disagree with that. I don't like that. I understand that you don't want the child to testify. It's a horrific thing to try to relive for the child. I understand that.
Doesn't have a reporting requirement.
That shouldn't equal a plea deal.
Only in the second offense, Judge.
I'm not a lawyer though, but that's just my opinion. The child shouldn't have to testify. Monkey. Flying Monkey has a channel. You should go check her out. She's awesome. She curses a lot and flips the bird in her thumbnails, which is why I love her. Yeah. Go check out Flying Monkey's channel. I'm not on YouTube right now. I'm in StreamYard, so I can't drop your link. But Monkey, I don't know if you're a mod or not, but someone drop Flying Monkey's channel if they want to or if they can. Sorry. Also, Sashina's here, another creator. Go check out her book. We're about to get a spicy love scene in her book. At least that's what people are saying. That's the rumor. Thank you, Jonathan Hart, for dropping her link. All right, I can't keep up with chat anymore. It's my chat keeps freezing and then fast forwarding a lot, so I don't know what's going on. But I'm just talking while the Judge Stevens is hardcore reading the facts of this case. Yeah, but go check out Flying Monkey and Sashina. Sashina's a writer. She also is a breeder of goat, sheep, pigs. No, not pigs. Goat, sheep. What was the third animal? Goat, sheep, cows. There we go. She's a breeder of goat, sheep, cows. They're cute. They look like cows. They jump like goats, but they're actually sheep. This is a sheep now. This is a zebra sheep. That's not a thing. Man, bear, pig. South Park reference. Love it. Kinda. I didn't remember there was this much downtime. This allows me to talk to the chat. There's only one breed of goats that faint. Monkey. Not every breed does that. It's a certain breed. At least that's what I think. I don't know. I really don't know. Sashina will know. Does Flying Monkey get a pilot license? Maybe. They probably have to be cleared with the FAA to fly over certain parts of cities and stadiums. Glenn, what did he do? We're about to hear it.
Thanks for your patience.
I don't want to start talking. All right, here we go. He's an evil human being, in my opinion. I don't remember exactly what he did. Like, it involves a minor. I don't remember how far it went. So, but it's a. I don't know if it's sexual assault. I don't know what it was. I don't know the exact charge, but it was dropped to. I don't remember. But we heard it a few minutes ago. But a felony dropped to a misdemeanor. And I don't know how any prosecutor in their right mind would drop touching a child from a felony to a misdemeanor. Every parent on this planet sees it the way I do. My girls are 7 and 8 years old. I would be in Texas right now, and I would be attacking him. I would be held in jail right now for this. I would not be happy with this. Indecent assault, yes. Thank you, Fishon. That's what it was. Terry, okay. I'm not going to highlight your message because I don't want that to be on screen, but yeah, that's what I wanted to say, but I don't remember exactly the details of this. I didn't really, like I said, I didn't want to cover this video. This is a very difficult video to watch, and I'm glad there's so much downtime so I can talk. Hey, Miss Shandy, thank you. Nope. Trying to highlight you. There you go. Thank you for coming. Also, we're running to the end.
Okay.
And now I'm going to shut up because when Judge Stevens talks, we stop talking.
This here. How old was the child? 10 years old?
Yes, sir.
So the only difference between this and the second degree decency with a child is the fact that y'all just dropped the age of the victim, right? As an element.
Yes, sir.
Everything else is the same.
Yes, sir.
Okay. All right. Anything else?
Not from us.
Okay. It looks like sex offender registration is not required yet.
It's not mandatory. I know, sir.
And it didn't get passed in this term, I guess.
No, sir. Not to my knowledge.
The statute says it's sexual offender registration is not required, and then it's in parentheses yet. So apparently, for whatever reason, they elected not to. The legislature elected not to change that other code. Anything else?
Not from us.
All right, and the defendant has entered his plea of guilty to this Class A misdemeanor. Is a pre-sentence report waived?
Yes.
Anything else to add? If not, I'm going to find Mr. Hernandez, you have pleaded guilty to this Class A misdemeanor, the lesser included offense of what is referred to as indecent assault. And under section 22.012 of the Texas Penal Code. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. However, I am going to follow this agreement, defer any finding of guilt, and place you on deferred or unadjudicated probation for 2 years. You are fined $500. There will be terms and conditions of probation, which are normal and customary for this type, a general type of offense, even though I wanted to go to sex offender classes and other things like that, that are normal and customary for other types of the offenses. And especially in light of the fact that the complainant was 10 years old at the time of this event. There will be other terms and conditions of probation which are normal and customary for this. Now, you're also going to do 180 days in the county jail.
Boom. I was waiting to pause it. 180 days. You guys all jumped the gun a little bit. Well, actually, yeah, you jumped the gun a little bit. You started reading that. Judge Stevens doesn't play. He doesn't play. And someone just said Cha. Hey, welcome Cha. Yeah, my internet sucks. If it's skipping, it could be on me, it could be on YouTube, I don't know. But yeah. All right. 180 days. He deserves it. He deserves it. Screw this guy. That's the maximum he could sentence him for a misdemeanor. And he did it. Like I said, love-hate relationship with Judge Stevens. He nailed this one. Like, sorry. And then, yeah. All right.
This is a crime of indecency. A 10-year-old child is victimized. You're going to pay a price for irreparable harm to a child on my watch. I just wish it was more. You took advantage of a 10-year-old more than once, according to the probable cause affidavit. And except for everybody just dropping the age, it's a second-degree felony. Plus mandatory reporting requirements for life, I believe. Otherwise. So what this court can do in managing the fair and appropriate remedy that I guess we can assess, although how do you take back the harm to a child? There is no way. You took advantage of a child. I have no sympathy for you. I have sympathy for the child. You took advantage of a 10-year-old child. Shame on you. You're going to jail immediately, 180 days, as a condition of this probation.
Your Honor.
Anything else?
Yes, Judge, if I may, considering that he's employed currently, will the court allow us to break that up in some way? I don't have something to proffer to the court right now, but I would at least like to ask the court to
Let me just say,
to consider.
Mr. Kelly is one of the most wonderful people I know. And he's a wonderful attorney, as well as just being a very fine, great man. He has children, and I know what he thinks. I know what we all think. You didn't give this child a chance to get ready for your assaultive behavior. And you did this more than once. And I have no sympathy for you. I'm not going to work on your terms, in spite of the fact I would do almost anything for Mr. Kelly. This doesn't have anything to do with Mr. Kelly. He's trying his best to help you, but he cannot undo your terrible misdeed. It was an unnatural act you performed on a child. Shame on you. You're going to jail. The most I can put you is 180 days. And that's what you're getting. That's what we call justice under these circumstances. Unfortunately, we can't undo the assault that you performed on a 10-year-old child. Shame on you. Anything else? That's in all due respect. If it was any other kind of circumstances, Tom, but I feel sorry for that child.
There we have it. There we have it. Told you that was going to be a tough one.
That is all.
Yeah, everyone's saying that he should be held more. I agree. I'm not a judge. I'm not a lawyer. I can't tell you. Let me pause it here because my outro is about to kick in. I don't know. Everyone's telling me he should. Yeah, I don't know. I don't know. Judge Stevens just said the most I can give you is 180 days, and I'm giving you the max I can give you. So I guess that means he accepts the plea. Yeah, I don't. The guy's going to jail for 180 days, and he's not gonna have a good time in jail. All right. Been live for an hour. I am signing off. My outro is about to hit in about 1 or 2 seconds, so you will be redirected to Begin. Say hi, Heineken. Heineken, haven't seen you in a while. Ever since Judge Simpson ended, I don't see you around, Heineken. But it's good to see you here. Anyways, let's go over to Begin. Let's say hi to him. Tell him that I sent you guys, and yeah. Until next time. All right, I gotta go through the spiel before I say bye. If you haven't done it already, please like and subscribe. Do your jump kick backflips. Also, donate to the what I don't remember what we called it now. The last thing that Jonathan said it was. I don't even remember. You know, my fund that's in the description. I would very much appreciate it. But until next time, bye.
Okay.